Alrighty, good evening, everyone. Welcome to week 6 of administrative law. Good to have you with us as we hurdle towards the Christmas break. This week, we are starting our journey into some really substantive stuff and looking at different grounds of review. And so, I give a lot of kind of introduction to these kind of ideas in the lecture videos, but today I'll do a little bit more sort of backgrounding on that stuff. And then we'll talk through our first ground of review for the unit, which will be no evidence, which is relatively straightforward. There's a little hiccup with the two-limb test, but reasonably straightforward. And so I think it's a good one for us to get started with, because it does highlight a lot of interesting things about judicial review and the grounds of review that we might use in a judicial review challenge. Before we get underway, just a few quick announcements. The first, obviously, we've got the Christmas break coming up next week, so no classes, no quizzes. It's basically time for Christmas, and then also assignment time, I suppose, if you're still working on those. I'm not going anywhere for Christmas, so I'll still be relatively at hand and checking emails and things like that. So if you do have questions, especially in relation to the assignment, of course, you're more than welcome to get in touch. I might be a little bit slower to reply, especially, I'm not going to reply on Christmas Day, but you'll still get a very prompt reply with those questions. The other announcement is that our week 7 tutorial falls on the 3rd of January, which is like the New Year's public holiday. Unfortunately, just due to sort of the limited number of tutorial slots available for law courses kind of throughout we're basically limited to in the evening, and no one wants to do a Friday, so only 4 days and things like that. So unfortunately, it's not really possible to reschedule that tutorial to another day. So we will be still running, even though it's a public holiday. Of course, that session will be recorded for those of you who can't make it. Once I've sorted it out, I'll make an announcement on Moodle. I'm looking at holding a sort of a makeup, catch up session later on in the week as well. And so if you can't make it on the Monday and don't have a clash with some other unit later in the week, I'll probably look at Wednesday. Then there will be it'll sort of run more, I suppose, as an informal sort of consultation time. So you'll be able to rock up and ask any last minute questions about the assignment, which will be due on the Friday. And then any questions that you have about the week 7 topic, which is a little bit tricky. So that's why I'm keen to really be highly available in that week. But just so it's, despite it being a public holiday, unfortunately, we do still need to hold that tutorial at the same time and day. Lastly, just sort of very briefly, I'm taking over another unit for a colleague who's had to go on sick leave, and that tutorial runs immediately after this one. So unfortunately, I will have to sort of keep to a hard deadline of 7 o'clock this evening. If our conversation is kind of running longer, or you've still got questions that we don't have time to get to, you're of course still more than welcome to reach out via Moodle or Teams or email me, and we'll address it. And if there's anything that I think really would have been good to discuss that we didn't get a chance to, then I might make a separate post or catch up video or something for that as well. So just to be aware of that if I start giving a hurry along at 6:55 or something. Before we get started today, are there any questions either about the content or about the assignment that's coming up in a couple of weeks, that due date? Perfect. All righty. Well, let's get underway. So, as I mentioned, we're really getting into the heart of our consideration of judicial review. And this week, we sort of look at two topics. The first is really kind of rolling on really smoothly from the week 4 stuff. And it's just some really sort of basic foundational ideas about judicial review, and in particular, thinking about when the courts do or don't like to get involved, and the kind of questions that they are really concerned with. And in particular, it's useful to remember that really with judicial review, we're sticking to issues of law, considering the legality of a decision, and often it can be helpful to think about, is there a problem with the process by which the decision is made? We're really definitely not focused on the content of the decision, right? That falls squarely within the merits review kind of category. So for the rest of the term, when we're thinking about judicial review, we're thinking about how was this decision made? How did the decision maker go about, well, for example, for this week in thinking about the evidence that the decision maker considered in reaching their decision. And if there are problems with that process, how did that impact the final decision? So it's really just a really clear and I suppose almost forceful reiteration. Judicial review, we're not interested necessarily in the content of the decision. We're interested in the process and the legality of that decision. The second sort of topic, and the main one that we'll be talking about in tonight's tutorial, is then our first ground of review. So we'll be looking at several grounds of review over the next month or so. And these are the sort of the key almost arguments that we use to challenge a decision. So you can almost sort of think of the grounds of review listed in the section 5 and 6 and 7 of the Administrative Decisions Judicial Review Act as kind of almost pre-made arguments that you can sort of use to point to the problems with a decision, right? So for example, this week with no evidence, we're looking at a decision for which it's not based on any evidence. And so if that's a problem that we can identify, we've got this ready-made argument, and all we need to do is establish that, the key elements are met and the way that it impacted the decision and things like that. So you can think of these grounds of review as options that we can use to identify the problems with the legality and the process of the decision. Before we get into that, we've got so question 1 from our hypothetical tutorials this evening, our tutorial hypothetical questions, is rewinds a little bit to the week 4 topic on standing, just because it's a pretty key issue. We sort of spend a little bit of time tonight going through it again before we move on to the grounds of review. So question 1 basically presents a range of different parties who may or may not have standing for a particular case, and we have to think about, okay, well, why might they or might not they be able to join in this application for a review. So the background scenario is the Great Barrier Reef Marine Park Authority is looking at some specific kind of dune grass, and there's an inquiry going on as to a particular company that's looking to do some stuff with this grass. So what we're interested in is whether these different parties that we'll run through in a minute might have standing in relation to this application as well. So I'll just run through them in the order in which they're presented. It sort of bounces around a little bit with some of the issues, but that's fine. So we'll start with the Cape York Land Council, who's the primary Indigenous advocacy group on Cape York. It claims to represent the descendants of the people who are recorded in the research that's presented in the facts. It's funded by Commonwealth and state governments and is a major player in politics of the Cape York. So what are your, I suppose, initial thoughts? And we'll run through these fairly quickly, but what are some initial thoughts on this one? Do we think Cape York Land Council would have standing for this application for review? To, I suppose, get the discussion started, what are some of the general ideas or principles that we need to think about in relation to standing generally? When would someone have standing, or when wouldn't they have standing?
I lost everyone there. I lost the whole lot, but I think I've got it back. I just
Okay,
caught the last bit of that about standing. Is it about legal interest being affected by the decision or something to that extent?
Yeah, absolutely. Can I maybe just get a quick some feedback in, maybe even just in the chat? Did I freeze, or maybe did Michael freeze? Just so I can make sure that you haven't all missed me.
I think it might have been me. My phone stopped Wi-Fi.
Right. Okay. Okay.
Please, it wasn't me.
All right, that's all good. No, I've got confirmation that I didn't freeze as well, so that's good. Yeah, so special interest test is really what we're thinking about here. And so what we're wanting to do with the special interest test is to show that the applicant has a special interest, which goes beyond sort of what an ordinary member of the public might have in a decision. And in particular, the kind of standard that we're thinking about is that the interest is more than merely an intellectual or emotional concern, right? So, it's not enough that you just feel strongly about the issue. There actually has to be some kind of substantive impact. And, usually there will be, but it's important to always just be double checking to make sure that we do have that. So thinking about the Cape York Land Council, and thinking about some of the cases that we discussed in the lecture videos, what have been some of the perspectives on First Nations peoples, and whether identification as a First Nations person, or some kind of issue relating to First Nations culture, whether that would be sufficient to be more than a merely intellectual or emotional concern?
I would have thought it was because of land rights, etc., and the relationship that the Cape York Land Council has to that reason or that area. And I would have expected that they would actually have standing in this matter.
Mm-hmm. Yep. Yeah, that's really good. Is there a particular case that you were thinking of in reaching that conclusion?
Oh, we could argue Mabo, but there are other ones though.
Yeah, Mabo's a tricky one in this context. The key cases that I'd be thinking about in relation to this, I suppose, is on the one hand, you've got Coe and Gordon, where the court found that just claiming to be, descended from First Nations people, or having First Nations ancestry in and of itself wouldn't necessarily be enough to have standing. And so that's relevant to the line in the facts about that the Land Council claims to represent the descendants of the people recorded in the research shows that, that might in itself might not be enough. However, usefully for the Land Council, there is also, its status as an advocacy group, its status as a major player in politics, suggest that it's got a current interest in the land that's the subject of this debate, and land management, and those are much more concrete or tangible interests, and so sort of becoming more analogous to the situation in Onus and Alcoa, we would expect therefore that would give the impetus for a claim for the Cape York Land Council to get involved. They would be able to argue that it's that connection to that land and the cultural significance of the land to First Nations people that would be more than merely intellectual or emotional. So yeah, I think the conclusion is absolutely right. I think they probably would have standing, and it's just a matter of stepping through kind of why that would be the case in a little more detail.
So if you could demonstrate that they had actually been responsible for signing some of the agreements between the different parties up at the Cape York Land Council and land, I'm not using the right term, I'm saying land rights, but there's another term that's used there for the connection to the land in terms of legislation. But if you could demonstrate that they had actually done that, then that would be sufficient to give them standing.
So you sort of thinking about native title claims?
So where they've got the native title agreements in place, if the Land Council, which I do know they have done, then they've done that with other councils in that area, that would actually give them standing, as I understood it.
Yeah, so I mean, native title in itself is tricky. It's beyond really. I mean, we don't have the facts in this one, but thinking more broadly, native title, because native title gives a really clear legal recognition of the claim, that would make it super clear cut. And yeah, you would expect that definitely, because then you don't even necessarily need to bring indigeneity into it. Obviously, it's intimately tied to the native title itself, but it actually just becomes a really clear cut issue that substantive rights are being affected by the decision or whatever's being reviewed. So if there was a native title agreement, then yes, absolutely, that would create standing. And I suppose what we're discussing here is, even if there wasn't, legally recognized native title for whatever reason, there still could be standing on the basis of, indigeneity and First Nations people's connection with the land. Let's push on to the second group, which is the North Queensland Conservation Council. It's funded through membership donations and grants, and it basically, does environmental and conservation stuff in North Queensland. It's got a close relationship with the authority and is regularly consulted on environmental management issues. What do we think about this one?
Yeah, possibility of standing, and maybe I can't find it. I know it's in here, and I only know about it because the Iwasaki Resort I used to go there. It's close to where I had a house. So
okay.
Someone in Commonwealth, but possibly I'll find it. I thought it was in the chapter, but I can't find it. But
no worries. Did anyone else want to jump in?
It was like a conservation foundation or federation or something like that.
Yeah, ACF. So yeah, thinking about ACF and Minister for Resources, and in particular the broad approach. So in the lecture videos, we kind of talk about environmental interests as providing, more than a mere intellectual or emotional concern, and contrasting between a narrow approach, which can be quite a small hoop to try and jump through to argue environmental interests, or the broader approach laid out in ACF and Minister for Resources. That would be useful in this instance, because in that case they talked about the Conservation Foundation's kind of clearly recognized status as an advocacy group in this space. They talked about receiving government funding as sort of legitimizing the group and the group's interest in, the particular space. The focus of the group. So, a group that is focused on a small or particular issue, it's more likely to have standing in relation to that issue. Whereas if it's something broader and I suppose more generalist, it can be a little bit harder to argue. Where the government or the decision maker has consulted with the group in the past, that again can sort of give it a level of legitimacy and make it easier to argue standing as well. So, and these are all boxes that the North Queensland Conservation Council ticks in relation to this Great Barrier Reef Authority. So yeah, we would expect that arguing for the broad approach under ACF and Minister for Resources, we'd expect that they probably would have standing as well. We can perhaps contrast that a little bit with Greenpeace Australia, which is the next group. They are an international environmental movement. They refuse financial support from governments and they rely solely on donations. They're a major national environmental organisation and they're consulted with by the federal government. What do we think about Greenpeace? Do you think they would have standing?
I fear you're going to say they do, but I personally wouldn't have thought they did, because they don't really have a connection to the area. They don't have a legal connection. Yes, they're an advisory group to the government, or the government does go to that, but I wouldn't have thought that connection that's required with the issues was actually there. They're more, I just didn't think they would be.
Yeah. I don't know that you need to fear that I would say that they would. But I suppose there's thinking, especially from an assessment perspective, I think there's something useful to unpack there. What I'm really interested in is your reasoning style, especially with a question like this. If you concluded one way or the other, that's important. But usually what I'm more interested in is the way that you go about arguing it, the reasons that you draw on and things like that. And I think that this really would be quite a debatable one. Greenpeace obviously would try and argue that they do have standing, and again, they'd use the broad approach from ACF and Minister for Resources. And they'd really draw on the fact that they're consulted with by the federal government. They might need to demonstrate that they're consulted with in relation to Great Barrier Reef issues, which on the facts, we can't say whether they are or not. But yeah, they don't have as many of the advantages as the North Queensland Conservation Council has in this space, right? They're not specifically targeted to issues in North Queensland or the Great Barrier Reef. They don't receive government funding. They are a much more kind of generalist organisation. And so they could make the argument, and potentially it would be successful, depends on some of the other facts, but I wouldn't think that it certainly wouldn't be as strong an argument as North Queensland Conservation Council. and it would be very possible that they wouldn't have standing in this instance. We'll press on because I'm looking at the time. Coalition for Economic Justice is a community group based in Brisbane, and they're supported by a range of different groups. The coalition objects to Agrico as a financial imperialist, proven environmental vandal, and immoral genetic engineer. Do we think that the Coalition for Economic Justice would have standing? I think we'd probably have difficulty arguing standing for these guys. Their interest really does seem to be just, intellectual and maybe emotional. There's nothing that really ties them to the Great Barrier Reef or the particular decisions that have been made or are proposed to be made. They just really kind of don't like Agrico because they don't agree with the way it conducts business, which, is their right to do so, but it doesn't give them a special interest in this particular decision. How about the Cooktown Coven, which is a belief group that believe in the tenets of Wicca? They've got 18 members, and really they believe in balance and harmony in all things, and they believe that interference with nature is problematic. And so they're concerned that Agrico's actions will interrupt the balance of things. Do you think that these guys would have standing?
I really think they should. I think we should go the Cooktown Coven. No, for obvious reasons. Whilst they do have connections to the area, they're not specifically focused around, they're not directly involved in the Great Barrier Reef as such.
Okay, yeah. Anyone else? I think this is another one of those ones that's probably a bit borderline, and I'd be open to arguments either way. Really, what we're kind of thinking about here is, on the one hand, in Ogle and Strickland, it's been recognised that religious belief can prove a special interest and can be more than merely intellectual or emotional. But thinking about sort of Right to Life Association and Department of Human Services, there really does need to be a clear connection between the belief and the decision. And so this might depend on how you characterize the nature of the belief, and then also the way that the Wiccan tenets kind of relate to that. So I would be open to arguments either way in this one. What would be important is to be sort of drawing on those cases that I mentioned and the sort of the perspectives laid out in those. And as long as you were doing that, I wouldn't be too worried about the conclusion that you reached. As I said, I'd be really interested in the way you use those cases and the way that you argue them. We'll jump through the next two quite briefly. So the Barrier Reef Regional Tourist Association and Westie Farmers have commercial interests most likely. I think the Tourist Association is very clear cut. Westie Farmers is potentially a little bit more problematic because the court is not keen on people and companies using the judicial review process to gain a business advantage. So Westie Farmers might be a little bit problematic on that front, but from Westie Farmers' perspective, they'd obviously be arguing that they have a commercial interest in this. And then Reverend Fred Stile, who's a member of the New South Wales Legislative Council, heard a rumor that an American company was going to do things with jeans and grass on Queensland beaches, and as a defender of the nation's morals, he suspects insidious influences. Reverend Styles' standing really kind of hinges on how we characterize his interest. Either we're thinking about him as a priest, in which case, are we thinking about a religious interest? He doesn't seem to be especially well informed of the issues, and so I would expect that the connection probably isn't quite there to establish that religious or spiritual belief is really driving a genuine interest in what's going on. As a member of Parliament, given that it's happening in New South Wales, that he sits in New South Wales, and this is all happening in North Queensland, we would expect that wouldn't be appropriate for him to be joining in a judicial review application as a member of Parliament. So that I've sort of whizzed through those last couple because I do want to move on to question 2. But are there any questions or comments on those last few? Perfect. All right, let's move on to question 2. Now we're thinking about grounds of review, and in particular, the no evidence ground of review that we're thinking about this week. So the main things that I really want you to focus on for this ground of review, of course, is just the sort of baseline. When we're using this ground of review, we're thinking about the decision maker having absolutely no evidence at all on which to base their decision, which, obviously it does happen. Otherwise, we wouldn't have these provisions, and we wouldn't have the case law to provide examples. But in practice, it tends not to happen very often. But the other thing to really keep in mind for this ground of review is the 2 limbs, which are quite similar and do sort of take a bit of thinking through. So if the 2 limbs are sort of tripping you up a bit, just sort of let it sit with you for a little bit, and then if you're still feeling a bit stuck with it, please do reach out. But hopefully working through this question will help a little bit with that. So the first limb is that there's no evidence to support an essential statutory requirement. So, if the statute lists let's say the decision maker has to find A, B, and C before they can make the decision, and they find A and C, but they don't find B, then there's no evidence to support an essential statutory requirement, and that first limb is met. The second limb is a little bit different. Obviously, there can be some overlap, but the second limb is a little bit different, which includes reliance by a decision maker on a non-existent fact. So let's say they base their decision on, A and B, but B didn't exist. And it wasn't necessarily essential that A and B exist, but nevertheless, they found A and B did not exist. It's possible, therefore, that there's no evidence on which to base the decision, and the whole decision is tainted by the non-existence of that fact. So just thinking through those 2 limbs and being able to identify, obviously, you'll identify that there's no evidence pretty easily, right? It's pretty clear when there's just nothing to go on. But then the trick is to being able to think through which limb it falls under. And that's the reason that that's important, again, comes back to this idea that in judicial review, we're thinking about the legality, the process by which the decision was reached. And there is a difference between a list of essential requirements and one of those requirements not being met, so the first limb, versus a decision maker just going about making the decision and seeing something that's not there, or thinking something is the case when it's not. Those are different processes. There are different problems with the reasoning behind each of those. And so given that the court is really keen on limiting itself to these issues of law and process, it is really important that we're able to identify exactly what's going on and what the problems are. So with that in mind, we'll sort of think about question 2. And the facts here are deliberately a little bit vague because it means that we can kind of play around with things and highlight a few different issues and stuff. So, you'll, in your exam many months away, you'll have more detail than this to go on. So it will be easier in some senses. But as I said, we keep it a bit vague for this question just to sort of play with some of the issues a bit more. So here we've got Fred, who's applied to be a federal police officer. The Federal Police Act requires that in order to be employed as a police officer, they have to be of good moral character. Sometime after sending in his application, he receives a letter asking him to provide more information about previous complaints that he had committed domestic violence and assault against various individuals. He provided evidence that all those complaints had been dismissed because of an insufficiency of evidence. And then he was subsequently surprised to receive a letter saying that he had not met the statutory requirement that he be of good moral character. What legal advice would we give to Fred? So let's start, as we usually do with these questions, with a bit of brainstorming, thinking about the issues that might be going on here, and then we can boil that down into thinking about an answer structure. So what are your immediate reactions to this? What might be some of the issues?
Are we heading into the territory of an error insofar as they've made a decision in relation to his moral suitability based on the existence of convictions that didn't in fact exist, whereas there's no information about whether or not they can rely on even charges to go to character. So, which would be interesting. Is that they've could make a decision to refuse a candidate if it was established there were prior convictions, but that fact did not exist. I get what you're totally saying about A versus B. Does it go in A or does it go in B?
Yeah, so here what we'd be interested in terms of thinking about more detail and more information that we'd need, in terms of the legislative requirements, what we'd be interested to know is on what basis the decision maker, concludes a person is or is not of good moral character. And does someone have to be convicted of a crime to show that they're of poor moral character, or is the existence of a mere complaint enough? So some clarity on the legislation is important. We'll revisit that, because that's one of the things that is kept deliberately vague so that we can explore some different implications. But absolutely great pickup. We need to know more about how you decide, or how the decision maker decides if someone is of good moral character or not. Absolutely. What else?
One of the things that really highlights to me in this is in the third area, which says Smith received a letter from the AFP asking him to provide more information about previous complaints. The question I would raise is, why did they do that? Because they have access to all the court systems. So why are they actually asking that? For him to provide further information about those complaints? What's the basis of using that information in assessing his good moral character?
That's a good question. It's it's an issue that we will return to in week 9 when we think about natural justice and procedural fairness, and really there's a principled reason and a practical reason that they would conduct themselves these ways. The practical reason being, they're busy people. Who knows how many hundreds of applications they get. They don't have, while they might have access to some of that information themselves, they don't necessarily have the time to be going out and doing all that kind of research for themselves. And so it's more efficient to just say, you know these things about your life really well. You just tell us the relevant parts and we'll go from there. So, from a practical perspective, it makes sense to ask him. From a principled perspective, one of the things that we'll talk about in week 9 is that in order to give an applicant or whoever procedural fairness in relation to a decision, it's important that they be given the right to respond to information or evidence that might adversely affect or result in a decision that's adverse to their application or whatever. And so, it's, as a matter of procedural fairness, it's important that if you've got, these complaints against Fred, it's important that Fred have the opportunity to respond to those and to say there's no evidence of this, as he said, or to own up and just say, yeah, that happened, and was 20 years ago, I've undergone counseling and therapy or whatever, and I'm a different person now, and I hope that you can see past that or something. So from a principled lens of procedural fairness, it also makes sense that they would ask him to comment on that information. But yeah, that's an issue for future weeks, so we won't worry too much about that now. But nevertheless, a good pickup that was part of the process, because what's interesting is that he's tried to provide more information, and they haven't necessarily paid any attention to it, which is interesting as well. What else stands out? Something else that there's a few things, but something else that might be useful to consider as well is this sort of gap or potential gap whereby the complaints were dismissed because of an insufficiency of evidence from a criminal law perspective, versus there being absolutely no evidence that they occurred at all, right? And to an extent, this comes back to Michael's comment about we need a bit more clarity about what sort of standard we're applying for good moral character and things like that. But it's possible, given that we're thinking about the sort of no evidence space, and the facts are pushing you to think that because the complaints were dismissed due to an insufficiency of evidence, that there is no evidence that the things that were complained to have happened, but that's not necessarily the case. It might just be that there wasn't enough evidence for a prosecutor to think that they could demonstrate beyond reasonable doubt that they occurred, but nevertheless there is some evidence that suggests that the assault and the domestic violence did happen. So that's sort of a gap in the facts at the moment.
The thing that stands out to me is that domestic violence, when there would have to have been a domestic violence in order in place, or a temporary protection order for him to have criminal charges brought against him, which would then lend to, and I wonder whether that would actually be a basis of what they're using to say, well, he didn't have a good moral character because there had to have been that temporary protection order at the very least, or full order in place against him for him to have those criminal charges.
Yep. So, and I think this really gets to the crux of some of the issues here, right? And so I think we might transition now into thinking about how we would step through this if it were an assessment problem. Obviously, if this were an assessment problem, you would get more detail, but nevertheless, it's useful to sort of to think about the thought process behind these things, and therefore how you can go about structuring an answer. First things first, thinking all the way back to week 2, what we would like to see is the really clear statement of the reasons for the decision, right? For one, this will tell us if the conclusion that he's of poor moral character has anything to do with the domestic violence and assault claims. Maybe it's about something completely different, in which case, there's potentially a whole range of other things that we need to think about. But for one thing, the reasons will tell us whether that's the basis of the rejection of the application. The other good thing about the reasons is that it will list the evidence that's been relied on to reach that conclusion. So that will really clearly highlight to us if there is any evidence at all to support this claim. And so this, that comes back to the point I was raising about there's a difference between an insufficiency of evidence from a criminal law perspective and there being absolutely no evidence at all. So we would want to see the reasons if they've been given, or to get reasons if they haven't been given, because that's, of course, going to be a really important starting point. From an information perspective, as Michael mentioned as well, we would want a bit more clarity about the legislative basis for thinking about whether a person has good moral character or not. Thinking then about the availability of judicial review. So this was our topic from week 4. We're thinking about jurisdiction, Commonwealth, because we're dealing with a Commonwealth Act, justiciability. Pretty straightforward, right? This is an administrative decision, a decision of administrative character made under an enactment, because this is a decision that only affects Fred, being made by the AFP commissioner or authorised delegate under the AFP Act.
Can I just quickly
throw
something in here, because I actually have to go.
Yeah, of course.
The reason I want to ask this question is because you've specifically used the AFP. Could the AFP turn it down because what you're asking him to get when you're doing this is actually a security clearance, and they could just turn around and say, we're not going to give you any of it because it is a security clearance, because that's what it comes under. Because that's why this question, it's just something that I'm going through. So that was something that I've just found very interesting, because that then comes on the banner of national security. Sorry, you don't go any further with that.
Yeah, so it's a great line. I like the line of thinking from the little bubble that is our study of administrative law in this unit. I can't really expect you to have knowledge of these kind of wider ideas and processes beyond what I give you. So yes, absolutely, in the real world there would be a broader set of background checks and a range of issues that potentially pop up there. From the perspective of would this be a how would this play, say, in an assessment scenario? For one, that I would give you more detail on the Federal Police Act, right? You've seen kind of from the midterm assessment how I run these things, but within that, I would only expect you to look at the provisions that are given, and so I wouldn't be expecting you to go out and research other parts of the AFP Act and other processes that are involved and things like that. But yeah, certainly from a I suppose real world perspective, there are definitely broader security-based considerations that are not just, is he of good character or not, that certainly would be applied and could be relevant here. So
I only do that just to make it very clear so that when we do go in exams, because sometimes some people do want us to go down that path and others don't. So that's good to setting boundaries as to what you want. That's really good.
Absolutely. So, and I mean, you will have seen, I suppose, from the midterm assessment as well, I use, I suppose, edited or made up bits of legislation for that reason as well. They're fairly grounded. There's nothing too out there necessarily. But yeah, I don't, because really what we're interested in admin law is the way that you think about the legislation and the processes involved, rather than necessarily, going out and finding 50 million different things. So yeah, I suppose the short answer is I like your thinking, but not needed necessarily for answering this question or this style of question in admin law. So I'll just, so the second, yeah, go ahead.
Oh, sorry, Jacob, I was going to say, is that a hint that we're not needing to go and have a look at the exclusions, the Schedule 1 exclusions and things like that? We're not down there. We're just a government agency not employing someone because they believe they're not of bad character, they're not of appropriate moral character based on the information they have, which may or may not be correct.
For this question or in general for the unit?
Oh, for this question, I think, but yeah.
For this question, I mean, yeah, there are some in the schedule. There are some exclusions for decisions by police commissioners and attorneys general and things like that. My immediate memory, and don't quote me on this, my immediate memory is that it's sort of hiring decisions don't really fall under it. It's more related to, decisions to prosecute or not. That's really what's targeted. So I wouldn't have immediately thought that a hiring decision would be excluded under the schedule, but don't quote me on that. It is possible that it's in there somewhere. But for this question, I wouldn't worry too much about it necessarily. For assessment, it's potentially, more relevant, or at least worth thinking about. So I was sort of talking about the availability of judicial review. We talked about jurisdiction. We talked about justiciability, and then obviously Fred is going to have standing as well, right? His clearly has more than a merely intellectual or emotional concern about whether he gets his application for employment with the AFP is successful or not. Then we think about the ground of review, and we're thinking about the no evidence ground of review, notwithstanding the limitations that we've talked about. So, not knowing necessarily whether there's any evidence of these complaints, not necessarily knowing much about the conclusion of moral character, quite what's required there. Potentially, we've got a situation where either A, or thinking about the first limb of the no evidence ground of review, it might be that the AFP has to establish that he's not of good moral character. So, in the legislation, if that was going to be the case, we would expect that the legislation would say, in deciding that a person is not of good moral character, the decision maker must find or must be satisfied that, A, the person has a criminal conviction, or B, the person is not well regarded in the community or something. So, a list of things, and the decision maker needs to be able to point to A or B or C or a combination of them in order to conclude that a person is not of good moral character. If the legislation was set out in that way, so a really clear, you have to find this, you have to find this particular stuff, then we would expect that there would be potentially no evidence under that first limb, because they have to establish that he's not of good moral character, and there's, not necessarily evidence that that is the case. And therefore, that conclusion is not open to them because there was no evidence that that was the case. An alternative approach is that, the legislation is worded a bit more flexibly, and it says, in deciding whether a person is of good moral character, the decision maker can consider, criminal record, previous complaints made against them, references from previous employers, a range of things. And it's not, you have to show these things. It's more a general, they're allowed to kind of just look at the situation and decide based on that. Potentially, we're looking at the second limb in arguing that the decision maker has made a finding of fact that Fred committed these assaults and acts of domestic violence when in fact those did not occur. That we'd be arguing there that the decision maker relied on a non-existent fact. And you can see there that, these two limbs really do butt right up against each other, right? There is scope for overlap between the two, but what we need to focus on is the way that the legislation is worded, the way that, whether there is a particular requirement or not, to point us to the first or second limb. Does that make sense? I can, on Moodle tomorrow, or Teams or both, if you'd like, what I can do is post a written example of that. It might be a bit clearer to see it in writing. If I sort of spell out, if this was the legislation, we would expect it to be the first limb, but if this was the legislation, we would expect it to be the second limb. That might be maybe an easier way of thinking through these issues.
Is that why, Jacob, just a question in relation to Curra? I only read Curra because obviously I work in a similar field, where Curra went under the second limb, the B limb, because it was based on the existence of a fact that they could extend their contract or whatever it was, or defer coal supply, and therefore didn't need the equipment, and that fact was not actually correct. That fact did not exist.
Yes. Yeah. So it's, both, of course, both perspectives rely on there being, no evidence to support whatever conclusion has been reached. But yeah, the difference really turns on the legislative requirements and the way that the decision maker has to go about, proving or establishing or thinking about what's been going on. So yeah, in Curra, that's why they sort of used the second limb. All right, unfortunately, as I said, I do have to call it there. I appreciate that we didn't quite get to the third question, but that's all right, because that's more of a theory-driven, principled kind of discussion. So it's fine that we didn't get to that one. If you do have questions, comments, or concerns about about no evidence, please do get in touch. And yeah, as I said, tomorrow I'll post up a written example to really highlight some of the differences between those as well. Excellent. Well, have a great Christmas, everyone. Have a good break. Good luck polishing off those assignments. And I'll see you all in the new year on 3rd of January. So looking forward to it. See you then. Bye.